All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Justice Francis isn't able to be with us here this week, but she will be participating in the disposition of these cases. Our first case today is case number 20-1685, Florida Bar versus Brian Rush. Whenever you're ready.
Thank you, Your Honor. May it please the court. My name is Brian Rush. I've been a member of the Florida Bar for 40 years. During that time, I have never been found to have been guilty of any violation of the bar rules. I served in the House of Representatives for 8 years. I was neither charged nor attacked for violations of the Florida Ethics Commission. I have 40 years of reputation as an honorable lawyer. I continue to defend myself in this case, and I would begin my argument this way, Your Honor. There are four standards that are relevant: de novo review of the contracts, de novo review of the rules of the Florida Bar, and the Florida Supreme Court's precedents in regard to contracts and eminent domain. The standard is clear and convincing evidence. It is our contention that there is no clear and convincing evidence to support the Bar's charges or the referee's report. Controlling Supreme Court precedents, there's four cases that are relevant. Wynn versus City of Cocoa is an eminent domain case. It dealt with a termination of the employment agreement, which is very similar factually. It's a 1953 or 54 case. Florida Supreme Court held that the standard is the reasonable value of an attorney's service upon termination of an eminent domain case.
Which case tells us that the standard is, as you suggest, clear and convincing evidence?
It's in the bar rules. That clear and convincing evidence is set forth in the bar rules as a standard of proof.
Which one?
By memory, I think it's 3-7.6 or 3-7.7, but it's in the rules that is in fact the standard. It's not preponderance. It's not the criminal standard. It's the intermediary standard. Those precedents, Wynn and Rosenberg, both Florida Supreme Court cases, Rosenberg 1993 or 94, again said that in a termination case, the question is, termination of employment case, the question is, what is the reasonable value of the attorney's service? Those are the exact words used in the termination clause of the Rush contract. Trial lawyers can only do their best to follow precedent. They look to precedent and they incorporate that in their agreements and their pleadings. The other two cases are Rowe and Quanstrom. Rowe and Quanstrom, in Rowe, the court set up a standard for awarding contingency risk multipliers and determined that the risk multiplier in a contingency case, primarily personal injury cases, would be somewhere between 1.5 and 3.0. In Quanstrom, the Florida Supreme Court said that contingency risk multiplier is not available in an eminent domain case. They are not contingency cases because of the way they are set up. And under the statute, 73.092, attorney's fees are set up in a variety of ways, but one of the ways is supplemental attorney's fees on an hourly basis. So the way the statute is set up, attorney's fees are not exactly contingent, and the Supreme Court held that because of the peculiar nature of eminent domain cases, in Quanstrom and Rowe, in Quanstrom they held that eminent domain cases were not contingent fee cases.
Eminent domain cases, your fee agreement with the client provided that fees will be paid by the Department of Transportation. However, the client will be responsible for the fees if the client terminated representation. Is that a standard clause in eminent domain cases?
Is a standard clause of lawyers in Central Florida. that, and it arises from the peculiarities of the representation. First of all, it's not a contingency fee case, and the condemning authority and the client can always do what they did in Wynn. They can terminate the lawyer on the eve of trial, take advantage of all of his work, in this case 4 years of work, 711 hours of attorney time, terminate the lawyer, and cut a deal between themselves. Additionally, it becomes apparent to the client as the case goes on that he can get a much better deal from FDOT if he eliminates the attorney's fee. And the attorney's fees, of course, in this case, are constitutional. Florida is not a just compensation state. The Constitution says full compensation. And the Florida Supreme Court, we filed a supplemental notice of authority, but the attorney's fees in an eminent domain case are part of just compensation. They're part of the Fifth Amendment, and they're part of the Constitution. So that the short answer is that is a common clause. Another common clause is a cooperation clause, that the client can't terminate the client or terminate the contract without being responsible. That's the holding in Wynn. Wynn, the Florida Supreme Court in Wynn versus Cocoa Beach held that if the client terminates the lawyer and settles on the side and doesn't pursue the attorney's fee, the client becomes liable for those fees.
Did the client, in your case, ever express the desire to terminate your services?
Yes.
When, more or less, when in this situation did they do that?
Generally the spring of 2018, after almost 4 years of representation, 3.5, 4 years, but they did it by a repudiation letter. Mr. Pettit, their attorney, sent me 2 letters, one on May 18th, 2018, and one on May 21st, 2018. It was shocking to see a lawyer put in writing a threat that he was going to file a bar complaint unless I agreed to give up my 2 fee agreements. And I had an eminent domain fee agreement and then a subsequent hourly fee agreement. The letters Mr. Pettit, on behalf of the client, sent, and the client signed an authorization with that, sought to extort me to sign a 1-page illegal fee agreement. Now, backing it up here, I can't sign an illegal fee agreement, a 1-page illegal fee agreement that says I cannot talk to the court, I cannot talk to opposing counsel, and I cannot talk to the client.
Let me ask you this. Have you gotten a fee for services related to the condemnation?
No, I haven't been paid anything.
Never gotten anything from anybody?
Not a dime. In fact, last year I made $15,000, Judge. I've spent enormous amounts of time and resource on this case. The client in this case hatched a scheme to eliminate the attorney's fees. Those extortion letters that their lawyers sent, May 18th, they're in the record, May 18th and May 21st, they say your fee agreement's illegal. They say that it violates Rule 4-1.5, and then they cite to a case which is an attorney's termination clause in a personal injury case where the termination clause contained liquidated damages and a penalty. My fee agreement doesn't contain any penalty. It doesn't contain any liquidated damages. It just says the quantum merit standard, reasonable value of attorney services, which is exactly what the Supreme Court's phrase was in Wynn and in Rosenberg. How is that a penalty provision? And the reasonable value of the services could be a big fat zero. Our contracts, all of our contracts with this client, these 2 contracts I'm talking about, the eminent domain contract and the hourly fee agreement that the client subsequently entered into, those were the 9th and 10th fee agreements signed by Mr. Taylor. Every single one, contrary to what the referee found, there wasn't a new provision regarding interpretation of ambiguities. It's in all of those previous 8 fee agreements which are in the record. You have extremely sophisticated clients, developer clients. I'd represented Mr. Taylor for 4 or 5 years. He signed a total of 10 fee agreements with me. Each one said that ambiguities would be construed, that the contract would be construed equally between the parties. Every one of them. So that provision wasn't new. The referee said it was new. That's not correct. It's erroneous. He said that the second hourly fee agreement didn't apply, even though that the second hourly fee agreement says for each additional hour of work, the attorney would be paid the princely sum of $395 an hour. That is well below the hourly rates in Tampa. That's not an unreasonable fee. The constitutional provisions are relevant. They're going to play out, I'm afraid. But the First Amendment is activated by commercial free speech. There's an allegation that Aloyma Sanchez made that I threatened her with a lawsuit if she interfered with the contract. I did do that. I told her that I would file a lawsuit against her if she interfered and violated Florida law, which also would have violated a court order at that time. I did warn her of that. One of the elements of interference is notice to the other side. Before I go any further, I'd like to leave about 3 or 4 minutes to 4 minutes, say, of my time for rebuttal. She then asserted, after a hearing where she had disparaged the expert witness who was not present, it was unsolicited disparagement of his fees in front of the court, and under the rules, I'm supposed to encourage her not to do that. It's not fair to someone who's not there, not represented, and is attacked on his fees, which are very important to these experts. They depend on getting paid as much as lawyers do, even more, I think. She then asserted that I had threatened to file a bar complaint against her. In this case, it's her word against mine. She has pointed to, she brought a witness with her who prepared the original Hobby memo. She produced an altered, fabricated document for 4 years. She shopped it during the arbitration. On the eve of the arbitration, she sent it to us by an email claiming she had just discovered it. On the 7th day of the bar trial, Mr. Hobby comes into court and he's got his original Hobby memo. Nowhere does it mention Florida bar complaint. Compare that to Aloyma Sanchez's memo, and she stuck in there the words Florida bar complaint. That's fabrication of evidence. We filed on the got this notice on the 7th day of the bar trial. After 4 years, we've been told what this memo is. We objected to it. We objected to the whole process at that point. We asked the court to schedule a show cause hearing. One lawyer stood up and opposed that, Florida Bar Council. They did not want to have a hearing on how it was that Sanchez had been shopping these two, and the counsel for the FDOT had filed an affidavit in the Florida bar case saying he'd produced all drafts plus all the metadata. We introduced into evidence metadata showing that the Hobby memo had been modified 5 times in a 1-month period, as late as August 16th, 2018. It was dated July 19th, 2018. You have absolute evidence of fraud by the FDOT. They didn't produce this document to us until the 7th day of a trial, 4 years after the charges were made. The referee didn't care. He said, "No problem, no problem. You're not prejudiced, and we're not going to do a show cause here, and we're not going to get into that." Make it simple, perhaps. There are several objectively lawful instruments. The 2014 eminent domain fee agreement is clear and unambiguous. The contract says, as set forth in this agreement, because I don't think I answered your question. It says, the first line is, as set forth in this agreement. That means you have to read the whole agreement. What the Florida Bar and the client have said is, oh no, we only have to read the first paragraph. That's the only thing we have to look at. If you look at subsequent paragraphs, we warn the client about the proposal for settlement statute, the offer of judgment statute. In those cases, the client can be liable for fees to the FDOT, and he can be liable, it says, if you don't accept an offer of judgment and we go to trial, then you have to pay our fees. There's nothing wrong with that provision, and there's nothing wrong with telling a client what the risks are, what the dangers are. Eminent domain practice is extremely complicated. The referee in this case said, if they had read the contract, because they didn't read the contract allegedly, if they'd read it, they wouldn't have understood it. That's not the standard. It's an objective standard. Can this court, when it reads the eminent domain contract, the 2014 contract, the fee agreement, and the 2018 fee agreement, can you understand it? It's an objective standard.
Counsel, could I get you to address an assertion by the other side that in the eminent domain case that the client wanted to achieve a settlement very quickly, but instead you filed unauthorized pleadings contrary to that and allegedly in your own interest? Could you address that?
Sure. The client wanted a settlement promptly. If you look at the April 12th meeting agenda authored by Jack Suarez, he said he wanted a prompt settlement within 13 days. That was later extended to early May and mid-May. because the contract kept getting extensions. I think that eventually they had 10 extensions. He wanted a quick settlement. But if you go back to that agenda, Suarez agenda, he said what was holding up the sale and the closing were engineering changes. They wanted a settlement where they wanted an existing 7-acre pond, not a small structure, plus easements, plus drainage structures, ditches, pipes, all sorts of things that are part of the order taking. As part of the settlement they wanted their lawyer to convince FDOT to move all that pond, the structures, the easements, 200, 300 feet eastward to create 14 waterfront projects. They wanted a quick settlement, but they had always wanted to move the pond so they would have a wider opening, a more attractive opening, and they wanted those 14 waterfront lots. That was the marching sign. They leave that out. The client very cleverly says, oh, we wanted a settlement agreement. Mr. Rush wouldn't try to get the settlement agreement. In my practice, when you're dealing with difficult opposing parties like FDOT can be and large corporations can be, you have to demonstrate leverage so that they will come to a settlement. The client directed us to pursue an aggressive settlement posture, set the case for trial, put pressure on them. There are memos from Jack Suarez, emails saying, set the case for trial so we can hold it over their head. That's a March 27, 2018 email. There's a March 27, 2018 email, same date by Mr. Taylor, the managing partner, saying, you got to tell them how much this is going to cost them if they don't move everything. That's what we did, and we did it through motion practice, which is how trial lawyers begin to notify the other side of the dangers they're facing. The pond that's attached to the...
So you're saying your motions were consistent and pursuant to your client's instructions, not in conflict?
I agree with that, yes, sir. They were impliedly authorized. But they're also part of the fee agreement. The fee agreement also discusses restoring access. That was one of the things we did. But there's an unbroken demand by the client from 2017, early 2017, until they settled without me in December of 2018, almost 2 years, unbroken effort to move the pond to restore access. Those motions were directed towards the idea that this was going to cause enormous severance damages. Our appraiser said $5.6 million. That's the number FDOT put in their settlement approval justification. This is a statutory required document. It's in the record. FDOT themselves recognized the damage, the severance damages of $5.6 million. In addition to that, we had land taken of 9 acres. This is not a small taking. It's a 400-acre development, 1,200 units, and they've taken all of the uplands, which are surrounded by wetlands. They've taken all of the uplands so they can build a retention pond. You can't build a retention pond in wetlands. It won't hold any water. So you have to go to uplands and dig it there. When they did that, they took our access to Sam Allen Road. Now, they didn't destroy it all. They left us what was about 30 feet. They reduced it from 110 feet to 30 feet from our plans.
Counsel, I'm sorry to interrupt you. You're down to under 3 minutes, just
Okay.
letting you know.
Thank you, Honor.
Thank you, Mr. Chief Justice, and may it please the court. My name is Tiffany Roddenberry, and I represent the Florida Bar. While there is no question that an attorney has a right to seek payment for their work, Mr. Rush's overzealous pursuit of his fees crossed the line in numerous respects. Mr. Rush engaged in a course of conduct that was designed to maximize his fee award, and he pursued payment of those fees without concern for the interests and objectives of his client. Because the referee's recommendations of guilt are supported by competent substantial evidence, and because the referee's recommendation is supported by the sanction standards in this court's case law, the Florida Bar asks the court to impose the recommended sanction of a 3-year suspension.
Counsel, could I have you perhaps summarize what evidence supported the referee's finding that Mr. Rush took actions against the direct instructions of his client? Because it seems to me like if there is competent and substantial evidence in the record that that in fact was the case, that's an important consideration for this court.
Yes, Your Honor, there were a number of actions. So beginning in the spring of 2018, the client's objectives changed where they wanted to get to a quick settlement. So at that point, they began taking actions, including directing Mr. Rush to begin trying to settle as opposed to pursuing certain non-monetary benefits. So when they brought in co-counsel, Mr. Pettit, at that point, Mr. Pettit there was growing concerns that Mr. Rush appeared preoccupied with gaining certain attorney's fees. So Mr. Pettit directed him to, for example, withdraw certain motions that were not in line with what the client wanted. Mr. Rush withdrew those motions, but not long after, again filed renewed motions that essentially made the same arguments. Mr. Rush, without his client's knowledge or consent, sent a settlement offer on May 4th, 2018 to FDOT. Within that settlement offer, he said that the clients were at that point willing to waive a substantial monetary benefit, which would in turn produce a non-monetary benefit on which he would earn fees. And then later, in late June 2018, when Mr. Pettit, on behalf of the clients, directed Mr. Rush to send a certain settlement offer to FDOT, Mr. Rush took it upon himself to change that settlement offer to preserve in his mind, to preserve his right to certain attorney's fees. Justice Curiel, you mentioned earlier, what is the applicable standard? And just to clarify, Mr. Rush continues to look to the standard of review that applied below, which was the clear and convincing evidence standard. But now he is before this court seeking review of the report of the referee. And now the standard is there evidence? He must show that there is no evidence in the record to support the referee's findings, or that the record clearly contradicts, and he cannot do that. First, the referee appropriately found that Mr. Rush violated Rule 4-1.5. This court has made clear in cases like Florida Bar versus Doe that a fee agreement containing a penalty provision runs afoul of the rule when the effect is to intimidate a client into not terminating their attorney's representation and to penalize that right. Here, Mr. Rush's 2014 representation agreement confusingly said both that he would look to only the condemning authority for his fees, but in the termination provision it said that should North Park elect to terminate, they would be responsible for the reasonable value of his services. Mr. Rush used that confusion and ambiguity to intimidate his clients into not terminating the representation agreement when they otherwise would have. Specifically, at the April 12, 2018 meeting with North Park, Mr. Rush at that time indicated that if his clients did not pursue the course of conduct that he wanted them to pursue, which would preserve his right to attorney's fees based on non-monetary benefits, that they could be on the hook for his fees, which he could only estimate at that point would be $300,000 to $1 million in legal fees. Mr. Rush's rough estimate at that point bears little relation to potentially the quantum Merowit value of his services, and it appears that that estimate was based on him achieving the non-monetary benefits that he wanted to achieve on behalf of the client. Notably, when the parties did settle the eminent domain case, the record shows, I believe in the testimony of Mr. Pettit and Mr. Rush himself, that the resulting attorney's fee based on the benefits achieved was around $110,000. And I can't speak to whether Mr. Rush was actually paid, Justice Kennedy, but the stipulated final judgment resulting from the attorney fee litigation that's in the record indicates that North Park ultimately agreed to an attorney's fee of around $115,000. As North Park's managing member, Jack Suarez credibly testified he was intimidated by what Mr. Rush's interpretation of the agreement. And he was concerned that if North Park did not settle in the way that Mr. Rush wanted it to, that they would be on the hook for potentially millions in dollars in legal fees, including when Mr. Suarez indicated the same at the May 24th, 2018 hearing in front of Judge Thomas, where he said before the judge that he was concerned that he was unsure what to do about Mr. Rush's representation because of the threat of fee liability.
Let me go back to where you said he made the threat to sue for attorney's fees based upon what he was certain valuations of the property and pursue a non-monetary course of action. As a matter of substantive law for eminent domain lawyers, if the client has two possible courses of avenue to pursue, perhaps with settlement with DOT, may an eminent domain lawyer make a claim for the higher valuation, even if a client chooses to go an alternative path?
No, Your Honor, I think that would be the decision of the client as to what, whether to pursue additional benefits.
And then the lawyer is essentially stuck with whatever choice they make so far as their course of action.
Yes, Your Honor. Under the eminent domain statute, it would be at least under subsection 1, in general cases, his fee would be based on the benefits achieved for the client. I think the client does have the ability to decide what benefits to pursue.
The benefits achieved, not the benefits that possibly could have been achieved.
That's right, Your Honor. Mr. Rush also tries to confuse things by pointing to his 2018 hourly fee agreement with North Park, but I think the record is clear that that agreement was limited to the preparation of a memorandum of understanding. It did not supplant his 2014 agreement under which he was asserting the right to attorney's fees, generally in the eminent domain case. The record also supports the finding that Mr. Rush violated Rule 4-3.4 by threatening his opposing counsel, Ms. Sanchez, with a bar complaint. The referee found that Ms. Sanchez credibly testified that after the July 18, 2018 hearing, he told her he would sue her for tortious interference, which Mr. Rush admits. But she also said, and the referee was entitled to credit her testimony, that he threatened a bar complaint. And he tied that threat to his ongoing pursuit of attorney's fees premised on the recovery of non-monetary benefits. Ms. Sanchez's testimony was enough to sustain the referee's finding, and Mr. Rush does not point to contradictory evidence that would undermine the referee's credibility determination. Mr. Rush again claims that his speech, to the extent he threatened her, it was protected, but this court has said in numerous cases that threats are not protected by the First Amendment, nor are baseless allegations. Mr. Rush again points to the Hobby Memorandum, which he says evidences there was fraud. To be clear, there is no evidence in the record that Ms. Sanchez falsified the Hobby Memorandum or anything else. What happened at the hearing was Mr. Hobby appears to have brought a different version to the final hearing, but Mr. Rush and his counsel had the opportunity to pursue additional action, including recalling Mr. Hobby to talk about and also issuing 2 subpoenas to FDOT custodians to investigate the issue. But at the final day of the hearing, his counsel said we were going to rely upon the fact that both versions of the memorandum were admitted into the record, as well as the fact that we have already elicited testimony from Mr. Hobby. The referee appropriately found that Mr. Rush's relentless and self-interested pursuit of his fees in contravention of the client's objectives violated the other rules charged in the complaint. As we discussed earlier, he filed motions that he had been directed to withdraw, and he repetitively filed motions asserting his right to fees at a time when he was not entitled to those fees as of yet. In addition, he made a settlement offer without his client's knowledge or approval, and that settlement offer was not revealed until later litigation. He also made a settlement offer that deviated from the express language he was directed to use, and to the extent he contends that he could not offer the exact settlement offer, I believe if you review the record, the settlement offer he was to send was a very simple document, and it contemplated the drafting of a stipulated final judgment that would have likely incorporated any language needed to preserve his right to fees. Just briefly, Your Honors, I want to speak to the sanction, which Mr. Rush did not speak to. The recommended suspension of 3 years is supported by the standards, and it has a reasonable basis in existing case law. The referee cited a number of cases that support an imposition of that suspension, including Florida Bar v. Comite, Florida Bar v. Scott, and Florida Bar v. Peterson. In Comite in particular, the respondent was found guilty of a number of rule violations, including, much like Mr. Rush, violations of 4-3.1, 4-3.4, and 4-8.4D. And the court said that while each individual violation standing alone might have justified a lesser suspension, the cumulative nature of the misconduct required the lengthiest suspension the court could order, which was a 3-year
How
suspension.
would you compare the harm to the client in this case to the harm to the client in those three?
Your Honor, the harm to the client in this case included the fact that they were delayed in resolving the eminent domain litigation. In Comite, it was more the harm to it was less harm to the actual client. In that case, it involved an attorney who was continuing to pursue attorney's fees, and it was actually harm to the opposing party who was pursuing the right to get fees, and then the respondent in Comite actually wrote to the assistant U.S. attorney and tried to get the opposing party criminally charged. So regardless, I think the harm to the client here was that their case was settled. I mean, their case was delayed. They also had to incur costs through their co-counsel or their additional counsel, Mr. Pettit, who they had to bring in to try to bring this into a landing.
Can I ask you a question about the cumulative stuff with the sanctions? Because I know our cases talk about that concept a lot. And I understand the idea of the cumulative misconduct when you have different victims or, a past case or something like that. But it seems like it's also gets applied in cases where you essentially have this kind of hodgepodge of bar rules that are kind of overlapping, and seems like there's a lot of discretion in terms of which you could charge, and the same conduct basically will be said to have violated several different rules, and then that gets described as cumulative, which then justifies a harsher punishment. I'm just curious how you think the court should think about the concept of the cumulative issue in terms of, what is appropriate to sort of treat it, or should we be asking about, distinct enough conduct, or should we be looking at just counting up the number of bar rules violated, or how should we be thinking about that?
Your Honor, I think it probably depends on the case. I don't know that it would be counting up the bar rules, but here it was one pursuit of attorney's fees, but it culminated in various actions that harm both the client, including their need to file additional counsel to get this case settled, and they had to, deal with numerous filings, including the Liz pendants that tied up their property. It also involved the separate conduct of Mr. Rush threatening his opposing counsel with a bar sanction. So I think cumulative here means that there were various actions. At every turn, he made things worse rather than better. And so those factors can be considered in deciding whether or not he is worthy of a 3-year suspension.
You mentioned that part of the harm is that Mr. Rush caused his clients to hire another lawyer to, like you said, bring this to a landing. Was the eminent domain case ultimately resolved by the new client, the new lawyer?
Yes, it was. It was resolved in late 2018.
Okay, and were the clients able to sell the property they were interested in selling?
Yes, Your Honor, to my knowledge, they were able to sell.
So from a monetary standpoint, there was no harm to the clients?
Other than having to pay additional counsel.
That's what this one mattered, but as far as the deal is concerned, there was no harm to the clients.
I think that's true, Your Honor.
So basically, they had to hire another lawyer to come in, pay his or her fees to bring it in, basically resolve the case.
Right, and they did have to face a separate lawsuit by Mr. Rush, which raised a number of claims that also involved fees for going through that arbitration, in addition to the fees they had to incur to dissolve the list pendants that was placed on the property.
Did Mr. Rush establish a lien for his attorney's fees in the case?
I believe he did. He filed numerous liens, and certainly we're not contending that he could not file an attorney's fee lien, but it is the bar's position that his Liz pendants, which tied up the broader North Park property in a separate lawsuit for fees, was improper and frivolous under the law. Consistent with the referee's findings, including on the aggravators, which Mr. Rush does not contest, Mr. Rush has insisted on portraying himself as the victim of a scheme to defraud him of fees, based on a theory of benefits his clients no longer wanted to pursue, and that he ultimately never achieved on behalf of his clients. This court's case law, including Comite, Scott, and Peterson, all support imposition of a 3-year suspension based on Mr. Rush's pattern of self-interested and unprofessional conduct. And for all those reasons, we ask the court to impose the recommended sanction. There are no further questions. Thank you.
I'll try to be brief. That's a bunch of baloney, and the client never changed their goal of moving that pond. As late as October 15th, 2018, 6 weeks before they settled the case, they were demanding that FDOT move that pond. The non-monetary benefits, it seems to be confusion about that. The non-monetary benefit is the flip side of severance damages. The appraiser said the severance damages from blocking access will cause $5.6 million in severance damages. If you do away with this by moving the pond, you will create non-monetary benefits and you will eliminate the severance damages. The severance damages at $5.6 million that's all part of eminent domain law. When you put a pond in the middle of the access road to a 1,200 unit development, you affect the value of the property dramatically. You affect access. I didn't seek non-monetary benefits. I sought to eliminate the severance damage, which triggered an attorney's fee that was 1/3 or less, probably a lot less.
Mr. Rush, were you authorized by the client to make the settlement offer you made on May 4th of 2014?
Yes. If you go back and look at the...
If you were, what is your argument that there was no competent, substantial evidence for the referee to disagree with you, as the referee did?
Well, because first of all, the North Park client, for 43 of the 44 months I represented them before I was repudiated, was Todd Taylor, not Jack Suarez. Most of this case is based on Jack Suarez's, I didn't understand the contract, I didn't know what was going on. Isn't it terrible what Mr. Rush did? I worked for Jack Suarez for 1 month, from April 18th to May 18th, when I got a termination letter saying that my fee agreements were illegal, and if I didn't withdraw them, I would get a bar grievance. The evidence is that the May 4th letter is substantively identical to letters sent on April 2nd, April 3rd, and then subsequently the same letters they sent. At trial, Mr. Pettit, my other friendly lawyer on the other side, he testified that Jack Suarez told us that he did not want any, he was not interested in it, and he was ready to waive, didn't care about any monetary compensation. That's fundamentally, first of all, that's an admission by the lawyer that we were told that Mr. Suarez, which we confirmed in a May 7th letter also, right after the May 4th letter, but the testimony at trial was the client no longer wanted the compensation. That compensation had been pegged by Mr. Taylor, the managing agent for 3.5 years, at $2.84 million. He sent us an offering, an appraisal on not appraisal, but an offering on a separate piece of property. Mr. Suarez was willing to trade all of the compensation for the 9 acres taken. In an eminent domain, there's land taken, and there is severance damages. Those are the big numbers. Mr. Suarez was willing to give up the claim for compensation for the property taken in order to get what are called the non-monetary benefits. I didn't come up with the non-monetary benefits.
Counsel, I'm sorry to interrupt you. You can have 30 seconds to wrap up.
I'll talk about the one issue. Aloyma Sanchez's testimony by herself that she heard me threaten her with a bar complaint is not clear and convincing evidence. If that's the case, then any lawyer in this state can be accused by one other lawyer of doing something that they heard, and that's sufficient. In this case, there is no question that the original Hobby memo that he brought on the 7th day of trial does not mention the words Florida bar complaint, and Aloyma Sanchez shopped at a modified memorandum that specifically added the words Florida bar complaint.
What happened in your 2 lawsuits for fees?
The court, we were directed to go to arbitration, and the arbitrator split the fee 80-20. The lawyer who'd done 4 years of work on the appraisals got 20%. The lawyer who, quote, landed it and kept asking for the same things we did, he represented the client for about 5 months. She gave him 80%.
What did you get?
I was awarded 20%, but I had to give that up.
Okay.
I had to give it up in order to get rid of that case.
All right.
I've never been paid anything in this case.
All right.
Thank you. We'll now take up case number 21-1450, Alahad versus State of Florida. Counsel.
May it please the court, Christine Garrity on behalf of petitioner Zavion Alahad. I'd like to reserve 4 minutes of my time for rebuttal. In this case, the court is asked to decide what standard appellate courts should use to review pretrial identification procedures for being unnecessarily suggestive. De novo is the most appropriate standard of review because it best addresses the ultimate purpose underlying the suppression issue, which is to ensure that improper police conduct does not result in the jury hearing evidence of an identification where there's a substantial likelihood that the identification is incorrect. I intend on arguing 3 points in support of this. First, de novo review creates consistency and uniformity in the application of law by ensuring that different courts judging substantially the same facts do not reach different outcomes. Just as important, de novo review develops a body of case law that provides law enforcement officers with a more precise standard of what procedures are constitutionally acceptable, so that the officers can rely on those procedures to obtain an identification that will not later be suppressed by the trial court. And third, the trial court is not in a better position than the appellate court to apply the constitutional principles to the facts of the case.
What about to make factual findings?
Excuse me?
What about to make factual findings?
The standard is that factual findings are reviewed for competent, substantial evidence in the record that supports them.
So you'd agree that the trial court is in a better position to make those
To make
findings.
the factual findings such as credibility or historical facts.
So then
correct.
help me understand why we should have a different standard in the show-up than we do in a photo lineup, right? Because in a photo lineup, that evidentiary call, you'd agree, we have traditionally reviewed for abuse of discretion, right?
I think that all pretrial identification standards should be reviewed for de novo review.
So you're asking us to change the law not just with respect to show-ups, but with respect to all pretrial identifications.
Well, with respect to show-ups, this is not an alteration in the law. This court's already determined in Walton versus State that de novo review is appropriate in terms of a show-up. And a show-up is what's in front of the court today.
Well, the state may or may not agree with your reading of Walton, of course, but perhaps maybe you can tell us why you think that's the correct reading of Walton.
Yes, sir.
Could you, I think it's important for the argument here to clarify at step one on the unnecessarily suggestive, what exactly it is that the court is supposed to be looking at, because it seems like there's some ambiguity in the case law as to whether it sort of accepts the premise that a show-up is suggestive and it only asks whether it was necessary to do a show-up versus an analysis that's more like what the fourth DCA did here, which is to sort of look at whatever happened on the law enforcement end during the show up, and then kind of doing this amorphous assessment of, what the court thinks about the propriety of whatever was done.
Well, I think that it's important to recognize that the determination of whether it's unnecessarily suggestive is not a fact in and of itself. It's a legal conclusion that's drawn from the historical facts that the trial court finds. This court's already determined that show-ups are inherently suggestive because they are just giving the witness one choice, one person to choose from. It would stand to reason then that in a case such as this, where there is another potential suspect, showing the witness that suspect as well would reduce that inherent suggestiveness. The district court acknowledged that it was a close call in this case as to whether the identification was impermissibly suggestive. It cited to the Walton opinion, but it applied an abuse of discretion standard.
Did it really, though, in the sense that it seems like the trial court could be read as having decided that step one was met, and that therefore it was necessary to look at the reliability of the identification, whereas it seems like the fourth DCA kind of preempted that decision at step one and substituted its own view of what the answer to that question was, and then cut off the analysis.
Well, I don't read the trial court's assessment of the facts as finding that initial suggestiveness prong was met. In fact, the court said that it was actually struggling to make that determination because of the fact that show-ups are inherently suggestive, and it didn't even begin the process with analyzing suggestiveness. It jumped right to the second prong of the test, the totality of the circumstances.
The one point that the fourth district seemed to have a problem with was the fact that there were two defendants with similar IDs present when the defendant in this case was apprehended and brought down, yet they chose not to show the second defendant to the witness to see whether she could identify him as the one. Wasn't that the strongest point the fourth DCA had for having concerns about this show-up? The fact that Nixon was not brought down for a
I do
show-up
think
as well?
that that's accurate. The case law has established that things like the suspect being handcuffed or being surrounded by police officers are not in and of themselves indicative of unnecessary suggestiveness. The additional fact here is that there was somebody else at the scene who matched the description, both the initial description that the witness gave and also the added details that she made at the show-up procedure.
Do you think that there's a possibility that the step one and step two are different enough that it could almost call for different standards of review for each step? I mean, it seems like step one is more law-ish and policy and what do appellate courts think is appropriate police conduct. It seems like step two is it's called application of law to facts, but it's very, very close to just a pure factual determination of whether the ID is reliable. And it seems like on that issue, there's zero institutional advantage of an appellate court over the trial court on looking at that question.
I would agree with Your Honor that the second prong, the weighing of totality of the circumstances, is pretty clearly a de novo analysis. But I also think that de novo...
That's the opposite of what I said, actually. The second step seems to me to be essentially a borderline factual finding. I mean, I know that it's technically considered application of law to facts, but not all applications of law to facts are equal. Some are closer to a pure fact finding, some are more law heavy. This one seems very fact heavy and therefore more appropriately kind of left at the discretion of the trial court. The first step one doesn't seem like it's necessarily in that same category.
Well, I would agree with Your Honor that step one is certainly not in that same category, and there are several practical reasons why that is so. The first is that a de novo review of the first step provides a consistent and uniform standard for what is an acceptably suggestive identification, so that the trial courts know where they should draw that line when they're considering whether to suppress the evidence.
Given the likelihood that the facts are going to be so unique, and given the fact that even under abuse of discretion review, the appellate courts can still sort of identify outliers and they can still write their opinions in a way that sort of, clarifies kind of, the boundaries of what sort of legally is at stake. It doesn't seem like the consistency thing is really that persuasive. I mean, it seems like there would have to be more kind of overlap factually than what is likely to be the reality out there in the world, which is that there's going to be so many variables in all these cases that I don't know that you're really going to have that much precedential value from what the appeals courts say about these things.
Well, I don't know that I agree with Your Honor that there is not a factual overlap on how these identification procedures proceed. There are very limited ways and a very limited number of variables, I think, that go into the actual procedure itself. And it does not seem out of the realm of sort of what's common that the same factual scenario that occurred here will occur in the future, which is when Mr. Alahad was found, he was together with at least one other person who also matched the eyewitness's description of who the shooter was or what the shooter looked like. And that was this man Nixon. It does not, that is not such a far-fetched factual scenario that it's not likely to occur again. And so in the sense that when the appellate courts review de novo on specific facts, that does give the trial courts some direction on how they should be looking at those facts or similar facts when they occur in the future. When attorneys are arguing really on any legal issue, but particularly on suppression issues, it is always comparing one case and the facts of that case to what has gone on in this case to try to figure out where that line is.
Go ahead.
It seems to me that, there are certain levels, like Justice Curry, I was talking about facts a while ago. That's, for the trial court to make, is there competent substantial evidence to support the factual findings, right? It seems like on de novo, you're looking at issues of substantive law, like, for example, is a show-up lawful at all? Is it constitutional? That seems a de novo determination as a matter of law. And then when you're looking at something that you should consider for to be unnecessarily suggestive, like in the Grant case, there are 5 factors to determine whether something is suggestive or not, unlawfully suggestive. What's determined in making that lawful determination seem like probably should be a de novo review to me, because you're establishing as a matter of law what that is, right? But then when you actually go to those 5 factors, for example, and make that determination in the trial, and the trial court makes that determination, why isn't that an application of the law to those facts, and the trial court should be making that determination, and we extend an abuse of discretion review to that?
Can I just clarify, Your Honor, are you asking about the second prong of the test, the totality of the circumstances?
Well, when a trial court reviews the factors to be determined whether this is misleading or not, why isn't that trial court determination of all those factors subject to an abuse of discretion standard of review, as opposed to de novo?
Again, are you asking me the court's factual findings or determining, making the conclusion that it was unnecessarily suggestive?
The conclusion that the trial court reaches based upon all the factors they're supposed to be looking at.
Well, it should be de novo to give, as I said earlier, consistency and uniformity not only to the trial courts when they're trying to determine what is that legal standard, where that line should be drawn, but also because police and law enforcement rely on what the courts tell them is lawful or unlawful procedure when they are putting collecting the evidence in the first place. And so police and law enforcement need to be able to rely on a somewhat objective line that is drawn, so they know that they cannot cross it, and if they do, evidence would be suppressed.
What's the standard of review for a trial court's determination regarding probable cause?
The appellate courts review that de novo. If it is a
Well, it's the mixed standard, right, on the historical facts.
Yes, competent substantial evidence to support the facts, and they review application of the law de novo. When we are talking about a warrantless search or seizure.
The courts, in terms of, though, it seems like at step one, courts could, under their kind of undisputed authority over pure questions of law. I mean, appellate courts could announce rules, legal rules that said, as Justice Polston, I think, was suggesting, it's per se a violation of due process to not, when the police are faced with two suspects who are close enough, it's per se a violation not to present both to the person, or it's per se a violation of due process to put them in handcuffs or surround them with police or whatever. And so those would be legal rules, right?
Yes.
But if the courts choose to leave it at this kind of amorphous, is it unnecessarily suggestive, then the court sort of deprives itself of articulating any kind of legal rules and leaves it to this more kind of quasi-factual determination. I guess what would you say is the legal rule that is being applied at step one? Because the 5 factors go to reliability. Is there sort of a closed set of factors that go in at step one to define what is quote unquote unnecessarily suggestive?
No, I think much like when the court is determining Fourth Amendment issues like reasonable suspicion or probable cause, there is no specific factor test that's applied. It really is whether the constitutional standard is violated is determined by sort of the application of the law to the facts. The court's judgment that it's unnecessarily suggestive. As a practical matter, I think that de novo review provides the parties with tools that they can use in real time to make that call. And by this, I most specifically mean police officers.
How would this determination that Justice Muniz is describing be different than what the trial court does when it weighs sort of the unfair prejudice versus the probative value of evidence, which they do all the time? It's a weighing sort of credibility, reliability determination. It's, I believe, always reviewed under an abuse of discretion standard. How is this particularly different?
Because in this case, we are talking about a larger constitutional principle and a line that the police cannot cross, as opposed to a judgment call about whether something is relevant or whether it is unfairly prejudicial or overly prejudicial. And so that determination of a 403 analysis really can only be made by an abuse of discretion. But when we are talking about a suppression issue with a constitutional basis, there needs to be a clear line that police know they are not able to cross. The only way that that can really be created is if the appellate courts engage in de novo review, which not only tells them what is not acceptable behavior, but also clearly tells them what is acceptable behavior, so they know how to apply that in the future.
Counsel, you're down to 2 minutes.
Yes, Your Honor, I'll reserve the rest of my time for rebuttal.
Mr. Chief Justice, and may it please the Court, the Fourth District properly applied abuse of discretion review to this question. I'd like to start at the top by clarifying our position in response to some of the questions, we do agree, for instance, with Justice Polston, that there is going to be de novo review of subsidiary questions of pure law anytime you do abuse of discretion review. And so to give an example, the Chief Justice asked about what is the substantive standard for prong 1. And I agree, we don't have a neat 5-factor test for prong 1 in the way that we do with prong 2 under Neal versus Biggers. But courts, even applying abuse of discretion review, can announce factors that they find to be significant and perhaps even dispositive. It's just that at the end of the day, applying those factors, they will defer where the trial judge's application was ultimately reasonable. And so doing abuse of discretion review, a court might say that when considering whether a show-up is unnecessarily suggestive, you could look at things like whether or not there are multiple individuals who truly fit the description. That's the kind of factor that you would, I think, look at de novo to ask whether, as a pure matter of law, that's relevant to the inquiry. And so you're going to get law clarification, even under the abuse of discretion review standard that we are advocating for. It's just that at the end of the day, in the ultimate accounting, you will ask whether or not what the trial judge did in the balance was reasonable, rather than whether it is what you yourselves would have done.
Say we agree. How do you win this case where you have a physically similar defendant down to the tattooed, tears on the cheek with gunpowder residue on his hands, and only Mr. Alahad is shown to the victim? Using the test you just articulated, don't you lose?
So we dispute the premise of the question that there is actually any physical similarity here, and you certainly can look at the photographs of the two men who, in our view, looked nothing alike except for the broadest, most general description. I think, in fact, if police had done, say, a two-man lineup with Mr. Alahad and Mr. Nixon, who were 8 years apart in age, clearly one of them is not a teenager, clearly one is a grown man, the facial structures are different, the skin color is different. If those two individuals had been placed together in a lineup, I think we'd be here and the defense's position would be that was an unduly suggestive lineup because the two gentlemen looked so dissimilar.
And that's only relevant at step one anyway. I mean, the reliability thing, because I'm assuming the relevance of the other suspect is on the unnecessary part of unnecessarily suggestive, right?
I'm not entirely sure it's not relevant to both, Your Honor.
How would it be? So how is the reliability of the? Isn't the reliability just based on what the witness was able to observe?
Well, I think it all goes to reliability. But I suppose you can make the argument, and we haven't carefully looked at this question because it's not the way that the case has been litigated, but I think a defendant might make the argument that, well, there was someone out there who resembled me, and had that person been there, the identification would have come out differently. So I'm not prepared to say it wouldn't be relevant under that prong. But going back to the traditional factors that courts have applied here, on law clarification, and this echoes Justice Scalia's opinion in Ornelas, you get very little law clarifying benefits when the legal question is so bound up in the facts that any one precedent is likely to effectively be constrained to whatever the particular factual mix of that case was. We think that that's exactly what you get with out-of-court identifications. Take the Neal versus Biggers factors. The first one is the opportunity for the eyewitness to get a good look at the perpetrator. Even within that factor, there are so many facts that might be relevant, including, was the witness wearing her glasses that day? Was it bright out? What time of day was it? Were there obstructions? Was she tired? How far away were they? If you change one of those facts in the factual mix, you might get a very different result. And so the point is that you don't get the same bang for your buck out of de novo review here because the precedents just don't go as far. Now, the second point on law clarification is that abuse of discretion review does suffice to provide law clarifying benefits. It can just in some instances take a little bit longer. Now, of course, you're going to get the law clarification that I referenced earlier, where when setting out the legal test, of course, you do de novo review. But even when doing application of law to fact, you get law clarifying benefits. It's just you get those not when you affirm, but instead when you reverse. Because on an issue of first impression, the trial judge's channel of discretion might look something like this, with each reversal, the appellate court has told future trial judges, don't do whatever that was, and so the channel of discretion gets narrower and narrower. Justice
Let
Curio.
me ask you a question, just so I'm unclear on what the demarcation point is here between abuse of discretion and de novo when we come into the case.
Sure.
What exactly, if a trial court makes all the factual findings, historical factual findings, and determination as to whether or not the show-up was suggestive or not, once those factual findings are made and we apply an abuse of discretion standard to it, then what is left for us to do on de novo?
So I think there are certain predicate legal questions before you do the application of law to fact. So if there's a dispute about, in this case, for instance, that there is a question about where certain facts are relevant, prong 1, prong 2, are they relevant at all? That's de novo review, because you look and you say, as a matter of law, a certain fact has legal relevance in a certain place in the analysis. So that law clarification is happening up front and we think is de novo. It's just that when you get to the back end application of law to fact, that's where the deference kicks in.
Can you help us understand, though, this? So a show-up is by definition suggestive, right?
The courts have said they're
Right.
inherently
Okay, the courts have
suggestive.
said that. So all of the work is being done by unnecessarily, right?
I agree.
Okay. So what are the factors then? And this is where the law comes in, right? What are the factors for? It seems like there's this disagreement potentially that the Fourth DCA talks about between the state courts and the federal courts as to whether exigency and all that is sort of the driving force versus all these kind of micro details about. It's never necessary for a police officer to say, we think this meets your description, you know, this person, or you know, anything that they would say almost you could say is unnecessary. So what are, and it seems like it's relevant to this question of what the review should be like, because depending on sort of how narrow or broad the necessity inquiry is, it can become more factual or more legal. So
Sure, but again, we don't dispute that when setting out the parameters of the legal test as to prong 1, there's going to be some de novo review that happens. This factor is relevant, this fact is not relevant. And I don't take the Fourth District to have done anything differently as to that. In fact, in the footnote, it didn't even purport to decide the relevance of Mr. Nixon's existence to prong 1. It assumed, I think, that his existence was relevant, but then it noted in the footnote, well, there's some disagreement about this point. And it's just that the application of law to fact ultimately got deference.
But you haven't answered the question as to how is a court supposed to know what is unnecessarily suggestive? So show up is suggestive. So what is unnecessarily? How are you supposed to do that first part?
So courts can articulate factors, and when they articulate factors, they do so de novo because those factors are a pure question of law. And so, you know, if you look at the body of case law, courts have talked about factors that are relevant, like whether or not police said anything to the eyewitness at the time of the identification that might have funneled the eyewitness in the direction of that particular perpetrator. That's the kind of factor that courts have said is relevant. Now, if there was an issue on appeal about was that factor relevant, I agree totally. I think this is what Justice Polson is getting at. That's de novo review, but that's not what was happening in this case. I think what happened in this case was that the application of law to fact got reviewed de novo. In fact, as I mentioned, the Fourth District seems to just have assumed the relevance of the fact that Mr. Nixon was out there. Justice Carroll, you asked a question of my friend about Walton's facts. Walton is not a show-up case. It's a photo array case. I mean, I looked, the cases that deal with show-ups are cases like Willacy, where the state cross-appealed, and this court applied abuse of discretion review to the question and affirmed as a result. So the more closely on-point precedents, I think, are abuse of discretion. That's relevant to both stare decisis as well as one of the factors we've identified here, which is a sort of history or practice.
Why should the standard be different for those two different categories? That escapes me.
I'm not sure that they should be.
Well, what possibility would there be that they should be different?
No, I think they probably should be the same.
Okay.
But if you are looking to draw from the precedent that's most closely on point for stare decisis purposes, I think that is will-see.
We want our precedent to be internally consistent, right?
I
On
agree.
a point like that.
I agree, and we think that all of these out-of-court identification procedures should be reviewed for abuse of discretion. But if you want to draw from the case law, that's the one that's most closely on point. Now, Your Honor asked a question about probable cause, which there are, of course, cases that apply de novo review to application of law to fact in that
Do you
setting.
think that's wrong?
I'm not here today to tell you that that's wrong. I mean, we may have a litigating position in that in some future case. But I think it's distinguishable in an important respect, which is that Fourth Amendment questions almost never go to the reliability of evidence. In fact, courts often lament when applying the exclusionary rule that they are forced to exclude from the jury's purview clearly relevant and reliable evidence obtained during searches and seizures. The key difference here, and Your Honor was pointing to it, the key difference here is that this issue looks a whole lot more like Rule 403. Where the real issue is reliability of evidence. That's the whole point of the due process inquiry, is to suss out unreliable identifications compared to those that we think are trustworthy.
And that's true about step 2, but not step 1. I mean, that's sort of what I'm struggling with, is that it seems like your case is super strong as to step 2, and it's just not equally strong as to step 1.
So I think that both prongs go to reliability, whether or not under prong 1, the procedure used is unduly suggestive, of course goes to reliability, because you're asking whether...
I'm sorry to interrupt you. I think that depends, though, on the necessarily part. If the necessarily is looking at things like exigency and all that, then reliability at step 1 doesn't have anything to do with it.
Well, I think on the whole, the inquiry goes to, and there might be constituent parts, but on the whole, the inquiry looks much more like 403. And just as a thought experiment, if you were to assume a world in which the U.S. Supreme Court had never said that the Due Process Clause protects defendants from unreliable out-of-court identifications, defendants like Mr. Alahad could still come before you and make all the same types of arguments that he raises in this case. He would just have to do so not under a constitutional rubric, but under Rule 403. And so, of course, if he raised those types of arguments in the trial court, lost, re-upped them in the DCA, you would instruct the DCA on a 403 analysis to do what they always do, which is ask whether there's been an abuse of discretion. Now, Your Honor asked earlier whether there might be a different standard of review that applies to prong 1 as compared to prong 2. There is some support for that in the case law. The 11th Circuit and the 10th Circuit both do something like that, although they've actually flipped the analysis. So they say that prong 1 looks more like a finding of fact and therefore gets clear error review. And then they do de novo application as to the ultimate question. But there's certainly an idea in the case law that you could split the baby in that way. And I think at the end of the day, if you were to say de novo review as to the first prong and deferential review as to the second, that's certainly better than the position that Mr. Alahad is advancing. Although on balance, we still think that this should be deference as to all prongs.
And your colleague didn't really emphasize this in her argument, but I'm just curious about your position on this issue of, the fact that it's a constitutional principle at stake, that should sort of push us more in the direction of de novo review.
Right, so we don't think that the nature of the right or the source from which the right is derived should be significant in the analysis. Constitutional rights, rule-based rights, statutory rights can all have an impact on the jury's verdict. So no, I think it's hard to say that the hearsay rule is any less important or that Rule 403 is any less important. I mean, some of what I think Mr. Alahad's argument turns on when they make the point that this is a constitutional issue is that constitutional issue will dictate the party or the conduct of third parties like law enforcement officers. But as we've discussed, there's relatively little law clarifying benefit to doing de novo review here because of the myriad fact patterns that might arise. And so either way, law enforcement are going to have to use their best judgment, and they're going to get law clarification from abuse of discretion review in any event.
Outside of the criminal context, are there other constitutional rights that are reviewed by abuse of discretion? Are major constitutional issues?
Sure. So, Arlington Heights and animus review is a great example where you do clear error review. But even in the criminal context, we've cited in the briefs 4 or 5 different contexts, and that's not an exhaustive list. But competency to proceed, which it's hard to imagine many legal rules that are more important to the outcome than competency. Ferretta, Batson challenges, where there's an allegation that the prosecutor used race in making a strike. All of those things get reviewed for abuse of discretion. And so I don't think it can be the case that the constitutional nature of this rule is dispositive. The last thing that I'll say about standards of review is that one of the considerations that courts have sometimes looked at is whether or not is the significance of the issue to the outcome at trial, and whether or not there are other safeguards that a defendant might invoke at trial to mitigate the harm of any erroneously introduced evidence. And so Justice Ginsburg made this point in Perry versus New Hampshire. There are plenty of safeguards that a defendant can rely on, even in the case where a suggestive identification procedure comes in. The right to counsel, the right to cross-examination, the beyond a reasonable doubt instruction. A couple of examples arise in this case itself. Florida Standard Jury Instruction 3.9c carefully instructs jurors to exercise caution when reviewing an eyewitness identification and lists many factors that they should think about, including factors like the Neal versus Biggers factors. Another example from this case is the fact that a defendant can bring in expert testimony on the reliability of eyewitness identification, and that's exactly what happened here. Mr. Alahad's witness was Dr. Neuschatz, who offered that kind of testimony, and the jury could take it all in. So the point I'd make is that the due process test really is designed to weed out the most suggestive and most unreliable out-of-court identifications. Abuse of discretion review allows courts to do that because when they affirm on abuse of discretion review, they're saying it was not unreasonable to conclude that this identification was not so suggestive as to have changed the outcome, and at that point, all of the other evidentiary safeguards kick in. So I'm happy to answer any questions that the court might have on the merits. But otherwise, I'm happy to submit our case. Thank you.
Thank you.
I'd like to begin by addressing the argument that abuse of discretion provides adequate law clarifying benefits, and I'd like to use the 4th DCA's opinion in this case as an example, because the 4th DCA reviewed for abuse of discretion, and it ultimately found that reasonable minds could differ as to whether the failure to provide Nixon in the lineup or in the show-up was unnecessarily suggestive. And what that means is that in the future, one trial court could find that it's not unnecessarily suggestive, and another trial court would find that it is unnecessarily suggestive. In the first instance, the evidence does not get suppressed, and in the second instance, it does get suppressed.
Right, but I guess the state's position there would be focusing on the unnecessarily piece of the test. If the two suspects are so easily distinguished, they were wearing different color clothes, for example, or they, were very easily, readily distinguished, then it wouldn't be unnecessarily suggestive to put just the one that matches the description before the defendant. So from a law clarifying standpoint, I think we're kind of at the same place where, again, it is a factually sort of sensitive determination. Isn't that really what they're saying? That, the trial court, having made a factual determination, perhaps in this case, that these two suspects were readily distinguishable, found it not unnecessarily suggestive. Are you asking us to adopt a rule that would deprive the trial court of the flexibility to do just that?
I am asking the court to adopt a rule that provides reliability, because in that situation where reasonable minds could differ on whether it's unnecessarily suggestive, that means two courts that come to opposite conclusions, their results are both going to be affirmed on appeal, which means the result that's left over after that is that there is no explanation for if the second person should be included in the show-up procedure, because some courts could find it's necessary and some courts could find it's not. In either way, under an abuse of discretion review, the appellate courts say it's okay. And so that's a problem with, that results in an inconsistent application of the law.
Unless anyone else has any questions up here, you can have 30 seconds left to
Thank
finish
you, Your
up.
Honor. Based on the arguments this morning, I would ask that the court decide that de novo review is the appropriate standard when courts are asked to review pretrial identification procedures for being unnecessarily suggestive. And I'd ask that the court remand the case to the 4th District Court of Appeal to apply the appropriate standard of review. Thank you.
Thank you. We'll now take a 10-minute recess. Thank you.
All rise. session. Please be seated.
We'll now take up case number 21-1767, Cruz versus the State of Florida.
Good morning. May it please the court and counsel. My name is Rafael Rodriguez. I represent Mr. Cruz on this direct appeal from the imposition of the death penalty against Mr. Cruz. This is Mr. Cruz's second visit to this court. Last year, this court vacated his death sentence based on the fact that the circuit court included information in his sentencing order that pertained to testimony in the co-defendant's trial. This court followed precedent by saying that was improper and vacated the death sentence. On remand, the circuit court reconsidered the imposition of the death penalty.
And we did just remand for a resentencing before the trial court, not a new sentencing phase, correct?
That is correct. The court reevaluated the case in light of this court's decision, which also found that there was no competent or substantial evidence to support the jury's specific finding that Mr. Cruz was the triggerman. Based on that, the circuit court actually made a finding that Mr. Cruz was not the shooter, and that's reflected in his resentencing order. He had previously stated that both defendants were equally culpable and had stated in his original order that the only thing that distinguished the two defendants was the fact that Mr. Cruz was the shooter pursuant to the court's special finding. On remand, the circuit court doubled down on its findings that Mr. Cruz and Mr. Charles, the co-defendant, were in fact equally culpable. He said that they acted in concert, they had equal footing, they participated equally. Culpability lies equally in their hands. Both defendants are equally culpable. These are findings of the circuit court that come to this court and should not be disturbed because there is competent and substantial evidence to support those findings. And in fact, the state does not make the argument that they're not equally culpable in their brief. The only difference between the two cases was now the fact that Mr. Cruz was no longer considered the triggerman. And that is the only difference in the reevaluation. The court failed to give an explanation in its resentencing order as to why it was giving disparate treatment to both defendants, even though he had found that both of them to be equally culpable.
Although from the judge's perspective, the variable that mattered was that sentencing Charles to death was not an option because of what the jury
That
had
is
found.
correct.
I mean, he could have thought Charles was equally deserving of the death penalty and just didn't have the legal authority to do that.
Well, the state never pursued that issue with the Charles jury because since they already had a
On the shooter, but they sought the death. Did they not seek the death? They sought the death penalty.
They
against
sought the
Charles,
death
right?
penalty. That's correct.
Right.
But in effect, once the jury had made a special finding in Mr. Cruz's case originally, he was basically foreclosed from arguing anything other than the fact that he was the shooter because there was a jury finding.
But obviously, a reasonable person looking at the facts of this horrible crime could conclude that it doesn't matter who the shooter was, and that they both deserve the death penalty. And in the case, the trial judge didn't have the authority to impose the death penalty on Charles. So the bottom line is, unless your whole case, I mean, it seems like it all rests on whether there's just sort of whether this relative culpability rule, whether that still stands, because the court saying that they're equally culpable doesn't really get you all the way that you need to go, because the implication of that could be that they both should have gotten the death penalty, not that neither should have.
Well, no, the point that I was trying to make is that is a settled fact in this case. Now, whether or not this court applies the relative culpability analysis is what the state is asking this court no longer to do in view of the Lawrence decision. So we're taking it one step further and saying that is the reality before this court. These are equally culpable defendants because there's nothing distinguishes between them. And what
to the extent that it relates to the particular circumstances of this crime, I think that's what that is about, correct?
Right.
That doesn't take into account other aggravation, and actually wouldn't take into account other mitigation either, right? You've got that as part of the analysis here. You've got what happened in the crime, and then you have circumstances related to aggravation and mitigation, which bear on the ultimate penalty that is to be imposed. Isn't that correct?
Well, insofar as aggravation, both of them were found to have the same aggravators.
Well, but there is this factor, and again, I don't know that this is legally dispositive, but it might have been what is part of what is going on in this case about the subsequent Hungry Howie's robbery and the findings of the court about the kind of the viciousness of the pistol whipping that the defendant here administered to one of the victims in that case. That is something that the court does dwell on. Isn't that correct?
It does. He makes that point, but remember that's an event in which both defendants participated, and that finding.
Well, but one person was doing the pistol whipping, right?
That's correct, Your Honor. But that was
the defendant in this case.
That is correct, but that was one aggravator that he was talking about, which is the prior conviction, which is applied to both defendants. And the circuit judge could easily, and this court has over the years reviewed circuit court opinions, could have easily laid out an issue as to why, for example, the mitigation in Mr. Charles's case may have verified or may have supported a life sentence, but no, he didn't do so. This court is deprived of that circuit court's reasoned judgment as to why he's treating these two defendants separately.
So can I ask you, I'm sorry, so let's assume that relative culpability went out the window with Lawrence. Is there any other legal principle that would warrant vacating this sentence just based on the fact that the jury that recommended death, a reasonable person could think that that recommendation was influenced heavily by the shooter finding, which we said was lacking in any evidentiary support?
So if I understand the court's question, it is whether or not there's any basis if you accept the fact that Lawrence did away with relative culpability?
Yes. So take that off the table. Is there any other legal basis for us?
Yeah, and we raised that in our brief, equal protection, which was not addressed in Lawrence.
Which has nothing to do with the shooter. Just forget about the other defendant and focus on the fact that the jury made a finding that had no evidentiary support according to our court, and that likely or plausibly influenced their death recommendation, which was obviously necessary in order for this person to get the death penalty.
Right, there is support for that, and that is that a jury's recommendation is not the end and be all of a judge's responsibility when he's considering the death penalty. This court has repeatedly said that the propriety of the death penalty is subject to the circuit court's reasoned judgment. And in this particular case, what we have is an indication by the circuit judge that the aggravators supported the jury's verdict, and that was the end of the discussion. He said, I'm not going to disturb the jury's verdict. But that is not the duty of the circuit judge at this point. The circuit judge, especially when he's viewing equally culpable defendants, is to demonstrate in his order why he's giving disparate treatment to these two defendants. We've raised the issue of equal protection because this court, as far back as Slater, nearly 50 years ago, said equal protection of the laws applies in this type of analysis. And it has done so in other cases which we set out in our brief. So in addition to that, we've also raised the due process clause of the state constitution, which this court can obviously interpret more broadly than any federal provision, because those are Florida state constitutional provisions that could be applied. We of course challenge the fact that Lawrence is determinative of this case, because Lawrence did not deal with relative culpability. It dealt exclusively with proportionality, and it relied on.
But haven't we overwhelmingly in our case law considered this the issue you're here on as kind of a subset of the proportionality issue?
This court has, on occasion, reviewed
Well,
it.
but I mean, I understand you have some cases that you
Yeah.
could argue we didn't. I understand that. But if you look at it as a whole, the body of case law where that has come up, isn't it a true statement that we have overwhelmingly treated it as a subset of our proportionality review?
You have. But this court has also 40 years ago said there are separate matters in the Palms versus Wainwright decision. And in that case, the defendant was trying to raise that issue, and the court says, no, no, no. These are separate and completely different issues that you're dealing with. So this court's opinions, yes, have used it, but there are other cases that have used them in different categories. And the point that I'm trying to make is that in the conformity clause, the jurisprudence of this court, it has been made very clear that in order for a Supreme Court case opinion to apply under the conformity clause, it must make clear and specifically hold a particular issue under that clause, under the, for example, cruel and unusual, or under the search and seizure procedures under Article 1, Section 12. That is not what happened in this case, because Pulley was simply involving comparative proportionality. Lawrence relied exclusively on Pulley, and Article 1, Section 17 requires a decision on the matter. The state has said, well, there's no decision that allows it to occur from the United States Supreme Court. But that turns the argument upside down, because the section of the Constitution, or Section 17, specifically refers to decision. To say to this court that the U.S. Supreme Court has never sanctioned it would be to basically handicap this court in its analysis of both search and seizure and cruel and unusual punishment, because we have to wait until the U.S. Supreme Court makes a decision specifically on an issue. That is not the intent of either one of those versions.
When did you say Palms was decided?
Palms versus Wainwright.
When did you say
that? Was 1984.
I thought you said 4 years ago.
No.
I think he did.
No, it was 40 years ago, I meant.
40 years. Okay.
40 years ago, yeah.
I know time flies nowadays.
And I would also point out that the state's argument that you should apply Lawrence also disregards this long line of cases from this court that this court does not intentionally intend to overrule decisions sub silentio. And that's also a line of cases that is before this court, because that is a doctrine that this court has applied. If we were to apply that doctrine, then Lawrence could not possibly have overruled relative culpability, because it was silent on the issue. There was no reference in Lawrence to relative culpability, zero. And in fact, it relied on the Jacob dissent. And the Jacob dissent, which was a single defendant case, didn't mention relative culpability. And it said very clearly that the Supreme Court decision makes clear, specifically holds that proportional comparative proportionality is not found, is not mandatory under the federal Constitution. But it said nothing about relative culpability. And this court has used that over and over again for the last 50 years. It even uses it in guidelines cases when there's differences between defendants. So it's not alien to the law of the state of Florida. And it makes sense that Lawrence would not have mentioned the McLeod footnote that was raised by the state in its brief, because it dealt with a completely different matter.
Wouldn't you agree, though, that as a matter of principle, the same things that make proportionality review kind of incoherent apply equally to relative culpability, in the sense of not being able to compare mitigation and aggravation and that sort of thing, that there are just too many variables to really have a principled way of even applying proportionality or relative culpability? I mean, they basically suffer from the same problems, don't they?
Well, there's two issues on that. One is comparative proportionality. This court never had any difficulty doing that. Absolutely none. For years and years, decades and decades.
I think that's probably in the eye of the beholder. But tell me why relative culpability in application is different from proportionality in terms of these issues that I asked about.
The main issue is you're looking at the same case. You're not looking at unrelated cases in the universe of cases. You're looking at the actors before the court, the actual individuals before the court. You're not looking at what happened in State versus Johnson and State versus Perez. You're not looking at that. You're looking at the case in front of you between the two defendants, the two actors in this case. And in fact, Edmond versus Tyson, which the state also relies on as the only feasible theory by which this court can assess co-defendants in a multi-defendant case, sanctions the looking of the relative roles of the defendants. The United States Supreme Court in Solomon versus Helm, cited in our brief, specifically talked about how Edmond talked about the differing culpabilities of the defendants. So it's not something that's completely alien to the law, and it is completely appropriate to deal with the actors in front of you. And in this case, this court is actually faced with a situation where the court has made a factual finding that they are equally culpable. He could have. Nothing prevents him from referring to mitigation as a difference, a distinction between the defendants, but he didn't do so. He did not do so. And this court should not be speculating.
But he does seem to focus on particular aggravation in this case. And even when he's coming down there to the bottom line conclusion, not just going through the individual aggravators, but on the conclusion about the imposition of the death sentence, he focuses to a significant extent on the video from the Hungry Howie's robbery, which he says that the jury saw the same and returned a verdict of death against Mr. Cruz. So there seems to be a lot of focus on that. Isn't that correct?
That is correct. That's what he wrote. But again, that refers to the one aggravator which applied to both defendants. Both defendants were found to have committed the same aggravator. So if that's the only aspect.
But we do know that the aggravators, that it's not inappropriate for a court to consider qualitative factors with respect to an aggravator. I mean, not every aggravator of this particular type would be equivalent. I mean, because the circumstances are different. It can be, so an aggravator can be more aggravated because of the particular conduct of the defendant associated with the aggravator. Isn't that correct?
That may be true, but...
Well, is it maybe true, or is it obviously true?
But because the only reason I say that is because the circuit judge said it didn't matter in this case who was the shooter or who was the one who inflicted the injuries. So who inflicted this injury at the Hungry Howie's shouldn't apply either, shouldn't matter to him either, but he said it did. And then on another aspect of his order...
I think he said the point about who was the shooter was, we don't know who the shooter was, okay? And so, and the idea that there can never be a death penalty in a case where you have two perpetrators and you don't know who the shooter is, we know that's not correct, don't we?
Well, we only know that when a court makes a specific finding in an order that this court can review. We can only know that. We cannot start speculating on what the circuit judge had in his mind. He had the ability. No one was standing over his shoulder saying, write this and write that.
I'm talking about the legal point that you need not establish, in a case where you've got two perpetrators, you need not establish who the shooter was for the death sentence to be imposed. Isn't that correct?
That is correct. But in this case, this court should not disregard the fact that this same judge in an earlier order found that to be the only salient difference between these two defendants. Then he did an about-face and said, well, it doesn't matter after all whether or not he was the shooter or who inflicted the injuries. So we're faced with an internal inconsistency within the same series of orders by this particular judge as to Mr. Cruz's the imposition of the death penalty against Mr. Cruz.
All right, counsel, you're down to 1 minute. You're only going to have 1 minute left for rebuttal. But so
okay, I will refer the 1 minute.
Thanks.
Good morning. May it please the court. My name is Patrick Bobek, and I represent the state in this case. 2 years ago in Lawrence v. State, this court recognized the importance of a U.S. Supreme Court case, Pulley v. Harris, which found that comparative proportionality review in capital sentencing cases is constitutionally permitted but not required. Because of this state's conformity clause in its constitution requiring this court to review cruel and unusual punishment cases, sorry, with U.S. Supreme Court precedent, it found that its comparative proportionality review violated that conformity clause. Relative culpability is, of course, proportionality review. I'd argue it's the quintessential form of proportionality review, because when you do proportionality review, you're attempting to find similar cases, and you can't get a more similar case than two co-defendants who committed the same crimes.
Wait a minute. Proportionality,
Yes.
it deals with whether the death penalty has been applied in similar type cases.
Right.
Okay. Now, relative culpability means that it could be whether the act, let's take hypothetically this case, where one defendant went in and did the killing while the other one was the lookout.
Right.
That's relative. That's why that deals. So they're two different things.
So I wouldn't, they're not two different things. Again, what you
We
do.
go back and forth, but I can say they're two different things.
Okay. But I would argue your precedent doesn't agree with that. As Justice Kennedy pointed out in his concurring opinion in McLeod, which ended up being the basis for a lot of the reasoning in Lawrence, he said that relative culpability is an aspect of relative proportionality. And in Corman v. State, this court said in a majority opinion, in evaluating proportionality, one of the factors that can be considered is the disparate treatment of co-defendants. So that's this court saying it's a factor of proportionality review. And then when you look at this court's cases, when it's applied relative culpability, it's always in using it as proportionality. When you reduce a sentence from death to life, this court always does so because it was disproportionate to the co-defendants.
Can you explain why, under your logic,
Yes.
even aggravators and mitigators aren't suspect? I mean, aggravators and mitigators by their nature are comparators, right?
Yes.
You're comparing a baseline case, a hypothetical baseline case, and saying there's an aggravator or a mitigating factor. If we accept your rule that comparisons among defendants are suspect because of Lawrence, what saves aggravators and mitigators?
Well, I'd argue because they are inherently subjective. The weighing process is inherently subjective. That's why we have the jury do it. That's why we have a judge review their findings and lay out the weight he gives to each of them. So they're not suspect. They're just, it's an inherently subjective process that the jury and the judge has to go through when they weigh those. And the Supreme Court has actually given us guidance on what to do with co-defendant cases. That's the Inman-Tyson test. All that, and the focus is always on the individual, which is in line with Supreme Court precedent saying you should have individualized sentencing in death penalty cases. And you should look at not just the conduct of the defendants, but their background, their unique characteristics, and everything about them. And the Inman-Tyson test just says the person must be a major participant in the crime and act with at least reckless indifference to human life. And this court has already found that Cruz meets that test. And since that's the only thing this court needs to apply in co-defendant cases, and it already has been found to exist, Cruz's death sentence should stand.
Could you talk to us about this particular case in this particular order, in the sense that it doesn't inspire a lot of confidence? I mean, you know, you've got a jury that makes a finding that's a critical finding that this court decided was lacking in evidentiary support. You have your initial order that your colleague focused on, the sentencing order. Then we have the do-over sentencing order that doesn't seem like it really attempted to kind of re-justify the imposition or re-explain the imposition of the death penalty in light of the shooter thing not being on the table anymore. You had a judge who repeatedly concluded that mitigators weren't proven, but then still assigned them weight. I mean, I don't know that legally what this court should or can do about that, but I'm curious to hear your perspective on sort of this particular order and, you know, how it's sort of legally justified.
Of course, and I think it's important to note that the first sentencing order came out in 2019 when this court still did a comparative proportionality review. And so that's why there was a focus on the jury finding that Cruz was the shooter, because the judge had to justify with relative culpability and proportionality review why Cruz was more culpable and why he could impose the death sentence. In this new sentencing order, it's post-Lawrence. He doesn't have to do proportionality review. He therefore doesn't have to do a relative culpability review. And so he just has to look at the aggravation and decide, does he agree with the jury that it outweighs the mitigation? And he exhaustively went through each aggravator, each mitigator, weighed them against each other, and agreed with the jury that aggravation outweighed mitigation. So the timing of the orders, I think, is important and explains what looks like a contradiction between the first and second.
Do you think, though, that, does it raise any red flags for you, though, when you read an order that seems to be so interested in sort of trying to justify a jury decision or to be appropriately deferential to that, when we now know that the jury's recommendation could very well have been infected by, a major error?
I think, if anything, he was more deferential to the defendant. Like you said, he would explain how he thought a mitigator didn't necessarily apply, but then find that it was proven. For example, that Cruz was a minor participant in a crime committed with someone else. He gave that moderate weight, but found that Cruz, under no circumstances, was a minor participant. And I think he gave it moderate weight because he was focusing on the fact that another participant was in the crime, which is part of the mitigator. I think that's why he found it as found. I think that's why he gave it moderate weight. So I don't think he was deferential to the jury's finding. I think he just agreed. This is a highly aggravated case. 5 aggravators, some mitigation, but not nearly enough to overcome some of the weightiest aggravators in this court's precedents. And so the death sentence was justified in this case. If there are no other questions, right, I just would ask that this court uphold the convictions and sentence of death. Thank you.
Very briefly, the second order did talk about proportionality even after Lawrence, so there's no timing issue here.
I think he was using that as a synonym for the weighing process, the weighing of the aggravators as opposed to the mitigators. If you look at it in context, wouldn't you think that's what he was talking about?
Well, he cited
because he wasn't really talking about other cases. He's talking about he's weighing the aggravators and mitigators.
I think he cited one case in that portion of the order, but in any event, again, we would argue that Edmund Tyson only applies to those threshold of cases below which a state cannot seek the death penalty. It doesn't talk about relative culpability, and it doesn't bind this court not to apply relative culpability. We conclude by asking this court to consider the following. The state's argument is asking this court to stroll into a legal minefield, to disregard this line of cases of sub silentio, to disregard its jurisprudence and the interpretation of the conformity clause, and to throw out relative culpability that has been applied in this court for over nearly 50 years. It asks for a radical reordering of this court's precedent. We'd ask that this court vacate the death penalty and request that the circuit court enter an order of life. Thank you.
Thank you. The court's adjourned.
All rise.